Travis Wayne Goodsell. After finding out this morning after midnight, and I did the video for earlier, that I've been sentenced to death, which is a recommendation of the magistrate Judge Oberg to the district judge Waddups. I've been given 2 weeks to file an objection. One of the problems that I was facing is that Judge Oberg refused to dismiss or deny the motion to dismiss of the defense, because they didn't follow, or they didn't have any claims that are sufficient grounds to justify it. For example, on the litigation.findlaw.com site, they list a number of grounds that the defense counsel were supposed to follow, and if they can't find sufficient legal deficiencies in my complaint, then they were just supposed to say, we are waiting to defend our client in a trial. So this initial phase is to weed out frivolous lawsuits. And that's what they claimed, is that my complaint was frivolous. The only problem is that the judge didn't find it frivolous. The first filing I filed, the judge found frivolous. So on November 1st, 2019, she held a hearing and was going to dismiss my case as frivolous, except that I dropped the bombshell. And so she gave me 30 days to file an amended complaint, which I did. And she never proceeded to dismiss my case as frivolous. Even the clerk said, oh, yeah, this is the proper way to do it. The only problem is that Judge first refused to do anything. She didn't allow me to serve the defendant. I had to find out that I needed to do a waiver of summons rather than having the marshal service do it, because I filed in forma pauperis, which was approved. And so the courts were supposed to serve the defendant, and the whole thing would have been handled instantly. But instead, she did nothing and ended her term on the bench, passing it off to the next judge, Judge Oberg. And Judge Oberg was immediately deny to dismiss my case. Judge first already allowed the case to proceed. So what's this new judge doing? Why is she not going after the motion to dismiss? And so these are some of the claims that a party, mostly the defense counsel, can claim. Insufficient service of process. The complaint and summons weren't served properly. They never made that claim. In fact, they exposed themselves of having been served with my original filing that I didn't serve them. So they accepted my filing, that it was properly served. So that one crossed off the list. Statute of limitations is expired. Nope, they never made any of that kind of a claim. I saw that they use Bill Cosby. his case. He tried to claim that, well, statute of limitations are up, client's innocent, glove doesn't fit. If you remember the O.J. Simpson trial. There's no issue of statute of limitations in regards to the allegations against the church, because they're capital crimes. There are no statute of limitations here. Lack of subject matter jurisdiction. Well, did I file properly? In the right court, against the right defendant, in the correct jurisdiction is involving the RICO case that I filed, and conspiracy in the follow-up. Which one was first? It was the jurisdiction of both, but they're only allowing me to do one jurisdiction. And the jurisdiction that I chose first was, I think, RICO. And that's why it's filed officially on the docket as RICO. But the filing for the amended changes it to 1985, because 1983 is just a one-on-one complaint, and whereas 1985 involves a conspiracy complaint that more than one person is involved. And because RICO is also involved, the more than one involved is a whole organization of a criminal nature, and thus RICO, thus a conspiracy. And so that was my jurisdiction. They tried to claim in the opening statement, not in the arguments, that it was the wrong jurisdiction, that it was in the conspiracy. But that's incorrect, and I pointed that out. It's the correct jurisdiction, and they were right to say that this is a conspiracy. They are a part of the conspiracy as the top brass of the criminal organization. And so that doesn't apply either. So it's the right people, the right defendant, right jurisdiction, the right court, etc. Improper venue. And so the venue is correct because Temple Square is in the venue of the 10th District Court, I think it's called, of Utah. And so correct venue. Failure to state a claim for which relief can be granted. They tried to pull this, but again, remember, my complaint was accepted, and so I put it in there. There was a claim for which relief was granted under the title, Request for Relief. So, no, I did that properly. They don't have a ground for this. And so the judges should have had denied their motion to dismiss. And they didn't file any grounds against each and every single complaint, which is required. Because if they can't find a reason to dismiss, then they need to go over each and every single count. And as we counted, 46 counts, I think. Or was it 42? I think 46. And so, for the defense counsel to not be told that their motion to dismiss was invalid, and that for the new Judge Oberg to say, oh, you filed your counter reply late. Oh, was I pissed. Oh, was I pissed. Because they filed late as well. They filed late first. They were supposed to file within 30 days of being served. They acknowledge in the motion that they got served properly and did not file on time. They even put the date of when of all this, and so it's well known and established in the docket that they were late and the judge did nothing against them. And so this is what I am going to have to go over in my objection. The legal grounds that were violated here. And as a new judge, I get to point out a whole bunch of them, don't I? But that's the whole point, is that she's expendable. She was only used for this purpose to deny my complaint, to deny my First Amendment right to petition for a redress of grievances. It was approved. It needed to go before a judge for a trial. I can't do a jury because either of us would be unfairly biased in a jury trial. Because if it were all Mormons, church is innocent, of course. If it were a trial of all ex-Mormons, church is guilty. And so it would be an unfair trial. And if the church lawyers recognized non-Mormons, and all they would have to do is search the church's membership records and say, this person's on the jury, they're Mormon. This person was excommunicated back in 73 and hadn't returned to the church. This person, they're part of the Women's Ordained Women organization. This one was part of the Protect LDS Children. This one is part of the Black Lives protest down at BYU that spray painted the BYU Brigham Young statue. This was one of the girls who were raped at BYU. See where we're going with this? It would be an unfair trial either way if we were to have it by jury. And there is nowhere in the world we could have a fair jury trial. And so it would, of necessity, be by judge. And hope that I don't get a Mormon judge who betrays America and is loyal to the church instead. So yes, I will be bringing that out as well, because Waddups is Mormon. He served a mission. He's gone to the temple. He has given the loyalty oaths. He's old enough to know that he's supposed to commit suicide if he betrays the church, even if his job is to serve the country first. And so these are the things that are going through my mind, but I still have to wait for the explanations as to why she's judged against me. And I have to wait a couple of days for the mailman. So, not cool. But my case is legitimate. It should have gone to the evidentiary hearing where I could have presented the evidence, and then they could be battling back and forth as to whether the evidence is legitimate or not. Like in Gaddy versus COP. Gaddy, Kay Birmingham presented the evidence list, as it was then motion to dismiss by the church lawyers, and then she refiled, and then motion to dismiss, and then she didn't refile. She asked for an extension till the 14th, I think, of July. So another week. I could check, but I'm not going to. For her to ask for an extension is strange. I don't understand why she's doing that. You'd think that she would have been prepared to go up against the church on this, as she is a lawyer, passing the bar, getting licensed, and has a client. I'm all by myself. The First Amendment guarantees me a prosecuting case, prosecutor counsel, whereas those who are accused are given defense counsel, and so that it can be fair in a representative government, Republican form of constitutional republic, that both sides don't stand before a judge and make their complaints back and forth. Instead, you have legal representation on both sides that are able to present the case legally and lawfully through the proper procedures and processes on your behalf, so that it doesn't become a circus or a shouting match or an all-out brawl. But again, government failed me, and so that's where we're at. So I was just filling you in on some of the things that I will be going over when I finally get the official paperwork from the postman, and the kinds of things that I will be going over in this. I will also be putting a personal note to Judge Oberg. As I'm guessing, I'm still searching to try to find who I email this objection motion to, because the magistrate judge is referring this to Clark Oberg for a final decision, and so I'm thinking him, but I may have to put it in to her, so I'll probably do all of them involved in this, but we'll see. The statute rule for the objection doesn't specify who I'm supposed to send it to. Utah is unique in that they have magistrate judges before being sent up to a district judge. So, yeah, I will be talking Mormon. It's mano a mano is the original phrase that's messing me up. One-on-one. And so Mormon on Mormon discussion. And turn this off, I think. And so, yeah, I'll have to figure out a way to summarize all of church history, as well as the current case and the nature of the case that I brought up, and specifically point out to him what he most likely doesn't know in regards to church history, the real church history. If he is in on it, if he is one of the Danites, Danite comes from Dan in Hebrew, which is judge, which were the Mormon terrorist group within Joseph's organization, which led to him being assassinated as a presidential candidate. But yeah, all of that information will have to be summarized somehow, probably in one sentence statements, because he would have gone, I'm not sure how old, I'd have to check how old he is, depending on when he went on his mission, depends on what kind of missionary discussions he had. Before me, there was the larger size, but it was still fairly new. So let's see if I can find out. Dad's generation. Okay, so no, he did the flannel board presentations and film strips. Oh God. So yeah, April 21st, 1946. So I'm also going to point out, are you that unsympathetic to what's going on right now with this coronavirus? Do you not have family? Do you not have loved ones? Do you not have ward members who have died or taken ill from coronavirus? And point out that this was supposed to have been prevented with Nelson as a medical doctor, and as medical doctors were being ignored by Governor Herbert. So yeah, everything is going to have to be laid out on the table, because I'm being denied my day in court, being denied presenting the evidence. And so I have to find a way to throw it all out there. Because all I did was, in the first hearing to dismiss my case, my original complaint, was, I'm going to copy this and go over it. But it was approved because I pointed out that the church had been paying the person who had me disappeared. I had the evidence. And so they're purposely preventing me from presenting that evidence. And the church is not able to come up with a legitimate claim for a motion to dismiss. They're just supposed to say, our client is not guilty and we look forward to seeing him in court. That's it. That's simple. And so then I present the evidence, and then they say, oh, well, this evidence isn't legitimate for such and such a reason, or we still maintain our innocence. We're going to fight this all the way and have this exposed in the press. Because that's usually after the presentation of the evidence, where the defense would say, oh, crap, let's plead to a lesser charge and see if they'll negotiate. No, they want this shut down. They do not want me to file anything against the church ever again, because that's what it means. Motion to dismiss with prejudice. And there is no justified motion to dismiss in their motion to dismiss, and the judges are refusing to recognize that as well. And even though I pointed it out, she still has denied it, and I find out Wednesday or so why she's denying it, and we go from there. Unbelievable.